All right. Hello, everyone, and
Hello.
good morning, Nina.
Yeah. Good
It's
morning, Matt.
yeah, good morning. Look, our intrepid leader Andrew has left us
He's
today.
abandoned us
Abandoned us.
for
He's not thought
nicer
about
weather.
not thought about the work designed for us, despite all
No.
of this chat about psychosocial
But
risks.
we know all about psychosocial risk, so we put in our own controls.
This is our paper cutout Andrew joining us today as he joins us live on messages. He didn't know that was going to appear, so enjoy paper cutout Andrew to watch over us as we go through the briefing today. Well, look, a fair bit of news this week before we get to our sort of big topic, which is obviously about the war for talent and poaching. Fair bit of news about a lot of different things.
Yeah.
Firstly, we wanted to chat to you about today really was Labor's Job Summit. It's coming up next week. If you've heard anything about it really in the media over the last couple of weeks, it's all been about the politics of it, who's attending, who's not attending, like it's the bell of the ball or something like that. But what we've done is we've gone through and had a look at what some of the real key things are for you that are going to be discussed in this, because it's going to set the IR and employment policy agenda for the Labor government for the next 3 years. So first one, Labor said they're going to rebalance the Fair Work Commission. A couple of different options on the table there, Nina, for us to look at.
It's really important as well because pretty much in the next 20 months, I think most of the senior Labor appointees will leave.
Yeah, exactly right. Vice President and President of the Fair Work Commission due to retire and be replaced. So Labor will absolutely be replacing those individuals and really setting the tone with the policy platform of the Commission moving forward. But interestingly enough, lots of different ideas, obviously, to, as they say, rebalance it because of all the Liberal appointees over the last 9 years. One is abolish it, start it afresh, which is just seemingly a pretty extreme thing, but it's been done before. Otherwise, maybe just expanding out its powers, establishing this Fair Work Court, perhaps.
Yeah, so it's an idea that's been thrown around a lot.
That's right. So get some new members in that way. So just broaden what it does. So lots of interesting things. Be a very keen eye on the shape of the Fair Work Commission out of this for the next couple of years. Now, Nina's topic that I riled her up on in the green room beforehand.
Lots of arguments.
What the unions are suggesting that they want to talk about at the summit. A couple of 4 real big things, but one I know the bargaining fees has really drawn your eye, Nina.
It's just absolutely ridiculous. So basically, the unions want to say that if they have assisted in negotiating the enterprise agreement and the other employees who aren't union members benefit, they should be able to charge them for the term of the agreement. I think it's about 70% of the member fees or something like that. But it's just not going to make any sense. It's clearly just a money grab.
No, that's look, I think it's very fair.
Yeah.
I mean, it doesn't seem like the sort of constructive thing about IR issues more generally.
No.
It does seem to be really union focused.
And they haven't thought about how it will work. Like sometimes employees represent themselves. What if there's multiple unions involved? How is it going to work?
Yeah, it's a bit, there's lacking nuance there, I think is the key thing. So it's, look, that'll be an interesting one to watch. Another one, they're talking about wanting to have a ban on unpaid overtime. Bit of a blunt instrument we were chatting about before.
Yeah, exactly. Well, overtime's not even an entitlement
that's right.
for award-free employees under the Fair Work Act. But like we've been speaking about numerous occasions, we've moved to flexible work. It has led to some people working more, but that really is a discussion that employees and employers should be having amongst themselves, thinking about work design. It's not really something you can whack with one.
No, that's right. I think, really, the union's sort of a blunt instrument solution here to a problem, again, that's a bit nuanced, that needs a little bit more detail to it. The other one, big one, overhauling the sponsorship system. So an interesting imposition, I think, for a lot of our clients who deal with labour hire and international labour, a bit of an odd proposal that the union have here.
Yeah, so the union are wanting to do a program where labour hire employees get 30% more than the medium average wage for the same job compared to local employees. And the premise behind it is they're intending to disincentivize the hiring of overseas labour and focus on Australian labour. But what they haven't considered is there is a huge shortage of workers across all industries, which is what we're going to talk about later. Yeah. And just there's going to be so many problems if you're needing to bring in this labour hire, who most of the time are on 3-4 year contracts, and they're going to be paid triple the amount of the local workers. That's just a recipe for disaster.
Oh, absolutely, Nana. I think, look, it's again, to repeat it, blunt instrument again for this. It's hard Nation wants to prioritise employing its own people, fine, but the way they're sort of approaching this, I think it's going to cause a bit of issue.
Haven't thought about the practical implications at all.
No, that's right. And then look, the final point is, look, this whole issue about the unilateral termination of enterprise agreements. Very interestingly, sort of, the Labor government's made a big deal out of this. So have the unions. Some stats out from sort of the applications last year. 99 occurred in total. Only 3 of those weren't opposed by the union, or had no one appear against them at all. So what is being built up to be this really huge issue, I think, probably a little bit smaller than it seems on the surface. So we're very interesting. We'll keep you updated as the Job Summit continues, but some real interesting practical discussions leading out of that. Look, interesting case we've had out sort of this week in a comment about sexual harassment too, Nina. Something I think we get asked about by clients all the time. What happens when, conduct that was welcome at the beginning is then claimed to be unwelcome after the fact. We've had an interesting Supreme Court decision on that one.
Yeah, so the Supreme Court decision was really a procedural decision, but the key things we need to look at are the facts of this one. So it was a circus performer who said she had an unwelcome sexual advance by the chairperson of the circus. And she actually wrote a book about the encounter, a fictional book based on fictional characters, which stepped through what had happened. And as a result, the chairperson wrote an email saying it was an autobiographical account. And that was enough to show that it was a complaint. And he basically blacklisted her in the industry. So she lost about 6 years worth of work. And so she filed a claim under the Equal Opportunity Act claiming victimization and sexual harassment. And what was really unique is the kiss that they were talking about at the time was completely consensual.
Yeah, and welcomed.
Yeah, in fact, I think she said she had butterflies or something in the description of the book. But what happened straight after is she got a call from his wife. She didn't know he was married at the time, who said, please don't break my marriage. Her friends were contacting her saying, don't be a homewrecker. And she then realized, look, she didn't want to be part of this. And the Supreme Court said that, look, the definition under the Equal Opportunity Act is to consider in all the circumstances. So something that could be welcome at the time can later actually be unwelcome, knowing all the circumstances behind it, such as the fact that if they were married. But that said, it doesn't mean that in situations where they were in a completely consensual relationship, they later break up, they try to then rewrite history. It's not opening the door for that.
No, it's absolutely right. It's not a Pandora's box in that sense. It's really about this deception. I think the key at the heart of this case is that what she believed at the time was actually based on false pretenses, which, in fairness, the alleged sexual harasser had created by not giving her all the information. So an interesting one, I think, just to keep in mind, sexual harassment, what might have been welcome at the time can absolutely become unwelcome, really. Something we've always, in fairness, really advised clients on. We're now getting some authority from the Supreme Court saying, look, this is very possible. So it's a really good shift in that sense. Look, another really great bit of news from the Fair Work Commission announcing that, look, on a fortnightly basis, they're going to be releasing wages data from enterprise agreements. We used to have to wait for this quarterly. So there used to be quite a gap. But now, really, I think, in light of the fact that inflation so high, the pressures so different, the Commission have said, look, we're going to start giving you this data more regularly, really real-time data. And look, interestingly, what it is showing, perhaps unsurprisingly, although not exactly what we had been seeing on a quarterly basis, at least since sort of the start of this inflation spike, union agreements actually having about a 0.5% percentage increase higher to the base wage rate than non-union EAs, but both staying quite far under inflation, really sort of 2.5% to 3.5%, which is a really fascinating development. But look, it's a really great source. We're going to keep using that into the future and rely on that when we're giving you advice about enterprise agreements and what's a good wage rate to put in there. Look, another sort of, I tried to fit in a don't set and forget around this, but don't set and forget your PPE doesn't quite work as well. But Nina, an interesting sort of comment about PPE here, a little bit of an interesting case about what not to do.
Yeah, as they often are.
Yeah, well, that's fair.
So Viva basically deals with hydrofluoric acid at one of their oil refineries. So workers have to test samples maybe twice a week. One of the workers got injured because it leaked out, ended up in hospital with burns and a sore throat. What was really interesting is for years, I think up to 2014, Viva had always implied the correct PPE, so minimum Class B or Class C in PPE. Then they unilaterally decided by themselves, no, we're not going to do this anymore. We're going to lower it downgrade to a Class A, which was just helmet, gloves and goggles, which is completely insufficient when dealing with acid. And the court basically said this is ridiculous. You cannot unilaterally decide for yourself what is appropriate. You know, you have to take steps which are reasonably practicable, and while resourcing is one of them, they had already proved that they could afford it, and they just chose to stop it by themselves.
So not necessarily a new lesson, but look, a great reminder again, you know, if you've got best practice, keep best practice. You know, it's not just enough to just
you don't get to move the poles about what is best practice.
And look, finally, sort of news items this week. Look, a really interesting High Court decision out in the defamation space about Google. Look, really finding that Google is not a publisher for defamation when it provides links to otherwise defamatory articles online. And look, I think real chilling or interesting effect here in the context of the workplace relations space, because, you know, I'm sure all of us have dealt with sort of ex-employees, you know, posting things on social media, blogs, etc., that are largely defamatory. Now, they might be a hard target to go after because they don't have funds. They're not really, it's not a lucrative sort of piece of litigation. Google might have been a sort of interesting target for that sort of content. But effectively what the High Court have said is, look, you can't knock on Google's door to have them take the links away. So have to be really careful here. Make sure you've got good social media policies, of course, in your workplace to prevent this sort of stuff from getting out there online to begin with. But just a reminder, you know, it's getting harder and harder in this space to go after.
Through the employees.
That's right. You know, not a lot of people with a lot of money. All right, well, look, on to the topic of today. You know, look, I think, you know, poaching in the war for talent, I think it's a really timely sort of reminder. I think everyone across the board listening in today would say, look, it doesn't matter what industry you're in, doesn't matter what you're doing, you know, the labour market, labour is scarce. It is hard to get. You know, as I commented earlier, Nina, it's not even necessarily about good or bad workers. It's just workers at all, right?
There's no workers anywhere.
Exactly. It doesn't matter where you are or what industry you're in. You know, there's labour scarcity. And look, Sophie's put together a really helpful sort of slide for us, I think, with some real headline numbers that just give some real context to why this is a problem. Sophie, if you don't mind chucking that up on the screen now, if we have it. But we'll talk to it while it magically works its way sort of in the background.
Magic in the background.
No, that's all right. Well, look, unemployment, you know, 3.4%. It's the lowest it's been since the 1980s, which is, you know, well before our time. Sorry for those at home. You know,
really
it's
rubbing it in
a little bit while Andrew's not here. That was an Andrew dig, but to the cardboard cutout, Andrew. You know, which is obviously huge. I mean, that's such a low rate of unemployment. You know, job vacancies up 111.1% since pre-pandemic, which is just crazy, you know, to think about it in that way. You know, Australia has the second most severe labour and skills shortage in the developed world.
In the world,
you know,
only behind Canada.
Only after Canada, which is, you know, a crazy sort of statistic. And really fascinatingly, you know, 37% of employers in a particular survey done by the National Skills Commission say we've got vacancies open, you know, for more than a month at this stage. I think here's the slide. There we go. So, I mean, really, the picture shows it. You know, it's sort of crazy sort of stuff out there, and all of this obviously is COVID-related legacy impacts. You know, obviously, start of the pandemic, a lot of international labour went home. Borders have been sort of opening up quite slowly. The focus seems to be, I think, domestic tourism, which is all well and good for a particular subset of the economy, but not bringing in, loosening those labour rules to get skilled international workers into Australia.
Those huge problems,
and then really mixing in with a lot of other sort of realities, things that were different things. We're seeing quiet quitting, things of that sort of nature.
Look, I think everyone focuses on the border closures and the lack of labour, overseas labour, but there's like wider impacts from the pandemic, even in the white collar professions. We're seeing, look, people reframing how they want to do work. We've spoken heaps about psychological regs, quiet quitting, people realising they want more flexibility, they want better options, and realising that they can ask for it because there is a labour shortage. Now, what kind of employee value proposition you put out there really matters. Because like we saw with parental leave, for example, a lot of the law firms put out what they thought were groundbreaking things, and now it's just the same as everyone else.
That's right. It's the standard.
It's moving
the expectation.
so fast.
Absolutely.
Yeah.
And it's a really different environment for things like that than it was, say, 5 years ago.
Yeah.
I mean, really, employees understand that they are the ones who sort of have the negotiating power in this space. So the expectations are great and they're really grand. So, and it's sort of like a practical sense, what we're sort of saying is, look, you really do need to look at what your employee value proposition is. And we acknowledge and we recognise, there's only so much money in the bank when it comes to this, but it's not just about REM. You can't just be adding up and adding up and adding up REM, because really there are other cost pressures, supply side pressures from COVID still that are impacting that. But what we're saying is have a look at your sort of policies. Have a think about what is your recruitment policy, what is sort of are you putting out there publicly. There's a lot of talk about Gen Z and millennial workers. They're looking for what your brand does, what it says, what its values are.
And a focus on well-being. Like, it's important to employees now. It's not, money's not enough anymore.
Yes, that's right.
Yeah.
That's right. So lots of different factors there. But look, what are we talking about? Sort of, you've tried all those sorts of measures, right? You've done your policies, you've gone out to market, you've had the job listing up there. It's quite logical to take your mind to the next step, which goes, well, look, I know my competitor has excellent employees. I'm going to try and poach those. And then sort of, what are some examples of what we're talking about that aren't poaching? And then what are some what we're talking about that are?
Yeah, look, I think it's a confusing thing because it's quite nuanced. So we were discussing heaps of examples, and even I got kind of confused.
Yeah.
But for example, I put to you, what happens if, say, FCW has a vacancy, Dylan, our HR manager, says, oh, look, we really need someone in the admin team. You go home and you talk to one of your friends because you think they'd be a great fit, and then they directly apply.
Yeah, so that's sort of not poaching.
No,
that's really not what we're talking
linked,
about
but
today.
it's not a direct poaching.
Exactly. Yeah, I mean, I think what we're really talking about today when we talk about poaching, and I'm sure some of you will be sitting there going, well, Matt, we know what poaching is, right? But we really want to emphasise what we're talking about here is, you've got a talent at the competitor that you want, and you directly go to them and make overtures either by yourself or through a recruiter as your agent, to try to get them to leave their current employment and come to you. And look, poaching's been happening since, time immemorial when it comes to, getting new employees. But the context that we just talked about, the war for talent, the labour supply limitations, it makes it a very different beast than it was even a couple of years ago. What we are seeing anecdotally is competitors, when they lose, think about it like this, really. Just as you're desperate to keep in your talent, so too are your competitors, And so if you're out there sort of poaching their talent, they're desperate to hold on to them. And what anecdotally we're starting to see is a greater appetite from competitors when they do have an employee be poached, to not just come after that employee, which we'll touch on briefly, but to come after you as the new employer.
To litigate,
to really start to litigate those, because where once, if they lost a good person, there were sort of 10 people in the line behind them to fill that role. There's no one there, right? So although, cost is tight, money is tight, we're seeing just more willingness to spend legal fees on those sorts of things. So what are the sort of things then? There's really two that we're talking about in terms of litigation. One, which we've touched on in the last couple of weeks, which is a post-employment restraint.
But that's, look, pursuing injunctions, account of profits, damages, but it's against the actual employee based on the terms of their contract.
That's right.
But more the focus on today, which a lot of people forget about, is...
it's the tort of interference with contractual relations, or the tort of inducing a breach of contract. And what's really important about this is it's your competitor going after you for your acts of helping that person breach the contract. And then there's really 5 elements to it, aren't there? Can you run us through those?
Yeah, so there has to be a contract in existence.
Got to be a contract?
Yeah, that can be written or oral, as we all know. The poacher has to know about the contract. That doesn't mean you have to know the specific of the clauses, just know that a contract is in existence. You have to know that any kind of breach or failure to do something would be a breach of the
Of
contract.
that contract, yep.
And you must induce the breach of the contract, and it must result in loss and damage.
That's right, to the competitor
Yes,
in that
that's right.
case. And look, importantly, the courts will say, look, you don't necessarily need to know all the details of the contract, but willful blindness or reckless indifference to you doing that person, you inducing someone to breach their contract and not knowing exactly that it would be a breach or being willfully blind to it, it'll be assumed to be knowledge in this
You
circumstance.
can't pretend you don't. It doesn't exist.
That's right. So
Not gonna
really,
work.
it's not enough. It's not enough to defend a claim in this space to simply say I've not seen the contract. Really, the courts will say, well, look, and in employment, it's really important. And I think just given timing, Nina, we might skip the 7 Network one, and we'll just use an example of a case called Employshaw and McMurphy. What this case really shows, Employshaw here had a long tenured employee who was working on a particular HR program, and its competitor, Elmo Software, had a competing product.
Great name.
It then poached this particular individual, McMurphy, from Employshaw. And importantly, Elmo Software didn't know what was in the terms of the contract from Employshaw and McMurphy. But what they did do, and what the court did say was, well, look, McMurphy, he actually didn't finish his notice period. He gave 4 weeks notice when he was required to give 3 months, and he commenced working for Elmo Software while he was still an employee of Employshaw. So Employshaw had an action against McMurphy in that space for a breach of his fiduciary duties, using his knowledge and his efforts when he should have been giving them to Employshaw to Elmo Software. And Elmo Software, to his advantage, that's right. And Elmo Software was liable for tort of inducing a breach of contract, because although they hadn't seen his contract, they knew that he should have been working for his employer at the time, or Employshaw, and they had him come work for them. So even though
to poach other employees too.
That's right. So although they hadn't seen the contract, that was enough. So real warning that we just want to make here about poaching is, look, you really just need to reassess your risk appetite for poaching in this current context. Not necessarily that it's not enough that you haven't seen the contract, but thinking about, look, what is the appetite of my competitor to litigate against me? Is the person I'm going after really key and central to them, and are they going to feel aggrieved? I think that's really the key practical takeaway for this. All right, well, look, on to the case study, which you've already heard me talk a lot, but it's my turn this week to read it out. All right, and we did have an argument about whether it was Ewan or Ewan. Now, I emphasise that Nina... Ewan, sorry, that's right. Now, Nina said, Matt, you have to say that it was Ewan, even though I knew it was Ewan. But that's just for Andrew to know that he didn't trip us up. All right, Ewan was the CFO at DimTech, a multinational technology business. His annual REM package was in excess of $1 million. DimTech's main product was an app to help commercial clients manage their electricity, gas, internet, and telephone needs in one place, providing them with the best prices and client outcomes. Ewan also mentored at the Mentone Business School for MBA students specialising in tech startups. The CEO at DimTech had approved the role. Ursula, one of Ewan's MBA mentees, didn't trip me up on that one, Andrew, graduated in 2020. As she launched with her own startup, Lineup, she leaned on Ewan for business modelling help. He also provided her with seed capital of over 100, I think that's meant to be $1,000 rather than kilometres, giving him a 25% shareholding in Lineup. Lineup had also developed an app similar to DimTech's, except it was for domestic users in Australia. At the time of helping her and making the financial investment, DimTech had started to develop an app for domestic users. Ewan had no access to the technology, but did know about the financial negotiations with suppliers in Australia. In August 2020, Lineup started a capital raise with 2 entrepreneurial businesses. One of the owners, Boris Petrovsky, undertook due diligence and saw that Ewan had shares in Lineup and was also the CFO of DimTech. Boris told his best friend, Sylvia, who happened to be chair of DimTech. 2 days later, Ewan's employment with DimTech was summarily terminated. All right, so 3 questions today. So please scan the QR code. Don't download the QR code, as Paper Andrew would say.
Never listen to Andrew.
No, that's right. That's right. Look, it's a bit of an interesting fact scenario, this one, I think, Nina. It's
something that actually happens probably more than we realise.
Well, that's right. And particularly in this startup entrepreneurial space, we've got lots of individuals, as our, Sydney team and Sydney clients would know. That's right. And the base that's here. They're often individuals who have their sort of, they've got a lot of hats, they've got a lot of
Yeah.
rings, you know, it's lots of different
And
things.
it's a
that they're-
moving space, so it's very common for like them to jump between startups.
Well,
as
exactly
well.
right. And
Yeah.
there's often times where there's a little bit of overlap. You know, I'm
Yeah.
working in entrepreneurial, you know, investment A. I'm
Yeah,
interested in
That's
entrepreneurial
true. They
investment
often
B.
are involved in a couple of startups.
That's right, and involved in lots of different capacities as
Yeah.
well. So, you know, employee, investor, shareholder, director. So there's a lot of potential for there to be some real overlap and some real potential issues in this space. All right, so question number 1, was Ewan acting in conflict of his interests with DimTech?
Oh,
Nina?
unquestionably, yes.
Yes, yeah.
Like he had knowledge, inside knowledge of it all, and he was clearly using it to his own advantage. He'd invested in a competitor. It was crazy.
That's right. So even though in the fact scenario, look, he didn't have the specific knowledge of this specific product, I think.
But he knew it was happening.
Well, that's right. And in the circumstances, what a court would likely look at and say is, look, you as an employee during this time, remembering he was the CFO, so remembering he was an employee, wasn't a director, but he as an employee, it's effectively, he owes those duties of loyalty to DimTech, which he wasn't really complying with, the fiduciary duties as well. Effectively, he had an obligation really to put in his full effort and time to that business, to
act in good faith,
yeah, and really, although the role as the mentor was approved, excuse me, by DimTech, the role as sort of active
an
participant,
investor, as well.
Investor, advisor in the other business wasn't. So absolutely, you know, acting in conflict of his interests, his obligations.
Highly doubt he disclosed that. To
no. Well, that's why, as it gets discovered later on, you know, the hammer falls in terms of the summary dismissal. So question 2, did Ewan breach his corporations law obligations? Look, again, yes, no. So here, it's sort of a section 183 of the Corporations Act. So, you know, maybe arguable about whether, you know, he was an officer of the business. He's clearly not a director on the fact scenario, but he is an employee, and he did have access to that sort of confidential information about the app. Now, it says in the fact scenario, you know, he didn't have access to the technology per se, but he did know about the financial arrangements. And there was a real possibility in his employment that he could use that information to the detriment of DimTech. And to some degree, the fact scenario indicates that that probably was quite likely here. You know, he must have known that there was an appetite for this based on not only his conversations with his former mentee, but for the fact that he invested 25%, you know, the 100,000.
And he
it's
knew
a buy-in.
Suppliers were interested, so he definitely was probably going to use that knowledge.
Well, exactly right. You know, in contrast to say sort of a normal entrepreneurial circumstance, it wasn't as if he was throwing his money behind something that he had no knowledge about. You know, he knew that the market was there because his own employer was engaging with the key players, the key suppliers in that market space. So big yes to question 2. Big yes. Let's add that to the catchphrases. So question 3. Was his termination flawed because of a lack of procedural fairness? And Nina?
Look, clearly there was no procedural fairness.
No, it's a yes again on this one. 3 yeses.
But
for
like,
today.
also, it's not as relevant because he made $1 million.
$1 million. $1 million.
He's definitely not going to file an unfair dismissal claim.
No, that's right.
And
jurisdictionally barred for sure.
Procedural fairness is not relevant to general protection. So yes, procedurally unfair, but what could he really do with that?
That's right. You know, look, there's nothing here in the fact scenario that gives us an inkling or a hint that there could be something general protections based. You know, obviously the termination in that way without the procedurally fair process, well, the termination itself, it's adverse action. There's no doubt about that. Well, what is the workplace right? Well, a little bit unclear here. What I would say generally is, you know, I think one of the things I always sort of advise in this space is, you know, even with your over high income threshold employees, putting in a procedurally fair process, at least giving them an opportunity to respond to allegations and so on, it's a wise move to make because employees who are terminated unexpectedly, and there's no doubt that Ewan would, they tend to go looking for what they think are the other might be the reason why their employment was terminated. 100%. And someone with $1 million a year in their pocket
got money to play with.
Has got money to play with in terms of litigating this and making big moves in that space. So look,
yeah, it doesn't even have to be a valid claim. Just they'll drag you through the media.
That's
for it,
right.
yeah.
That's right. And you know, through the Fair Work Commission, I mean, it's just over $100 to put an application form in. I think that's the thing to always remember. And in the hands of a good plaintiff lawyer, you know, they'd have a field day with this one. They really would. You'd get a list or a letter from a particular plaintiff employment firm that we've all seen, alleging 16 different, the 10-pager, alleging sort of 16 different exercises of workplace rights that you would never have seen. So, look, yes. There was flawed because of a lack of procedural fairness, less of a risk for the unfairness whistle, but general protections risk there. So look, thanks so much, everyone.
Yeah, thanks, everyone.
Thanks for tuning in this week and tuning in to see Paper Andrew contribute. As always, thanks so much for tuning in. If you could please, react on the LinkedIn post. We really value your engagement.
We love all the comments that we received today. We just ran out of time.
Absolutely. And look, we'll try to get to those which we see. But thank you so much for your engagement. It helps us heaps. And we hope to see you tune in next week. All right.
Bye.
Thanks, everyone. Bye. Bye.